One burning ship in Sydney Harbour rewrote the rules of negligence, and a child with a lamp in Edinburgh settled them for good. Today, we break down causation and remoteness, the two bridges between a defendant's breach and a claimant's damages. Once duty and breach are established, the claimant must still prove two more things. First, that the breach factually caused the damage, causation, and second, that the type of damage was not too remote from the breach. These are sequential hurdles, and we'll tick them off in order. The starting point is the but-for test. The claimant asks, but for the defendant's breach, would the damage have occurred? If the answer is no, the breach was necessary for the harm, causation is established. If the harm would have happened anyway, the claim fails. The clearest illustration is Barnett v. Chelsea and Kensington Hospital Management Committee in 1969. A man attended an A&E department and was sent away without examination. He later died of arsenic poisoning. The hospital had clearly breached its duty, but medical evidence showed he would have died, even with prompt treatment. The arsenic was too advanced. Because the harm would have occurred regardless of the breach, the but-for test was not satisfied and the claim failed. Simple in its logic, but powerful in its effect. The but-for test can be too strict, where multiple causes operate simultaneously. The exception is material contribution to harm. In Bonington Castings v. Wardlaw in 1956, Mr. Wardlaw developed pneumoconiosis from inhaling silica dust at work. Some of that dust came from a source the employer was liable for. Some did not. He could not prove which dust caused the disease. The House of Lords held that because the guilty dust had materially contributed to his overall disease, causation was satisfied. The defendant did not escape simply because innocent causes were also present. The breach need not be the sole cause, it just needs to be more than negligible. A further extension applies where the claimant cannot identify which of several defendants caused the harm. In McGee, 4th National Coal Board in 1973, Mr. McGee worked in brick kilns and developed dermatitis. He was exposed to brick dust at work. Some of that exposure was in breach of duty, some was not. Medical science could not say which exposure triggered the disease. The House of Lords held that materially increasing the risk of harm was, on the facts, equivalent to materially contributing to it. This was taken further in Fairchild v. Glenhaven Funeral Services in 2002, where the claimant had been employed by multiple employers and developed mesothelioma from asbestos, but could not prove which employer's fibers caused the tumour. The House of Lords confirmed that where each defendant had materially increased the risk of the very disease contracted, the claimant could recover against all of them. This exceptional rule is tightly controlled. It applies where the mechanism of causation is scientifically uncertain, there are multiple defendants all in breach of the same duty, and the disease is indivisible. Sometimes a claimant is already in a weakened position when the defendant's breach strikes, or a second event occurs after the tort. In Baker v. Willoughby in 1970, the claimant had suffered a leg injury through the defendant's negligence. Before trial, an unconnected armed robbery left him with the same leg amputated. The House of Lords held the defendant remained liable for the original injury and its consequences. The later tort did not eliminate the defendant's liability. But compare Jobling v. Associated Dairies in 1982. Here a pre-existing back condition, a natural disease, supervened after a workplace tort. The House of Lords held that the defendant's liability was limited to the period before the disease would have disabled the claimant anyway. The courts therefore distinguish between a subsequent tort, where the original defendant remains liable, and a subsequent natural event, where they may not. These cases sit in tension and the area remains difficult. Even if causation is proved, the defendant is only liable for damage of a reasonably foreseeable type. This is the test from the Wagon Mound No. 1 in 1961. Oil was negligently spilled into Sydney Harbour and drifted to a wharf where welding was in progress. Sparks ignited cotton waste floating on the oil, which then set fire to the wharf. The Privy Council held that while spillage and fouling of the wharf was foreseeable, damage by fire was not. The defendants were not liable for the fire damage. The foreseeability test replaced the older direct consequences test. It asks not whether the claimant suffered damage, but whether the type of damage was reasonably foreseeable. Crucially, the precise manner in which that damage occurred need not be foreseen. In Hughes IV, Lord Advocate in 1963, workmen left a manhole covered only by a tent and paraffin lamps. A child took a lamp into the manhole. The lamp fell, causing an explosion and burning the child. The House of Lords held that burns from the lamp were a foreseeable type of harm, even though an explosion of this unusual kind was not, so the defendants were fully liable. The thin skull rule, sometimes called the eggshell skull rule, qualifies remoteness. Once a foreseeable type of harm is established, the defendant must take the victim as they find them. If the claimant has an unusual vulnerability that causes the harm to be far more severe than it would be for an ordinary person, the defendant is liable for the full extent, even if that extent was entirely unforeseeable. The leading case is Smith v. Leach, Brain & Co. in 1962. A worker was splashed on the lip by molten metal, a foreseeable burn, but the burn triggered a precancerous condition and he developed cancer and died. Lord Parker CJ held that because the type of injury, a burn, was foreseeable, the defendant was liable for all consequences, including the cancer. The two rules work in harmony. Remoteness requires foreseeability of the type of harm. The thin skull rule then says once that threshold is crossed, there is no cap on the severity or extent of what the defendant must pay for. Let's check your understanding. Ahmad negligently spills chemicals at work. Bella, who has a rare and unknown skin condition, suffers severe burns, far worse than any other worker. Is Ahmad liable for Bella's severe injury? Option A. No. The extent of harm was unforeseeable, so the chain is broken. Option B. Yes. The type of harm, a burn, was foreseeable, and the thin skull rule covers the extent. Option C. No. The but-for test fails because others were also injured. Option D. Yes, but only if Ahmad knew about Bella's condition. The answer is B. The wagon mound. No one requires the type of harm to be foreseeable. Burns from a chemical spill clearly qualify. The thin skull rule in Smith v. Leach Brain then means Ahmad is liable for the full severity of Bella's injury, even though he could not have foreseen how badly she would be affected. To succeed in causation, the claimant must satisfy the but-for test, or bring themselves within the material contribution exceptions. Remoteness then demands that the type of damage was foreseeable, but once that threshold is crossed, the thin skull rule means the defendant bears the full extent of harm, however severe. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.